The Bloemfontein Magistrate Court granted Moroadi Cholota 2,500 rand bail after a lengthy 3-day bail application last month. Magistrate Estelle De Lange told the court that she didn't think Cholota was a flight risk, as the National Prosecuting Authority indicated, and that she neither was the reason the case has previously been continually delayed. Once De Lange read her judgment and granted the bail, Cholota bowed down and cried, looking relieved and happy. During the bail application process, the NPA submitted that if Cholota wanted to attend trial, her extradition from the USA wouldn't have been necessary.
The applicant, through her advocate, indicates that she wants to attend the trial. Now, with respect, everything that she did in the past few years indicates precisely the opposite. If she wanted to attend the trial, why didn't she come back to South Africa? After an undertaking was given in a high court before the judge president in Bloemfontein, why didn't she? We would have had a trial date a long time ago. We would have been busy with this trial already had it not been for certain of the accused, co-accused of this applicant. We brought a number of applications in the High Court which were dismissed, and that is the main reason why we struggled to get a trial date. Now, in a sense, it worked in the favor of the state, or to the advantage of the state, because in the meanwhile, Ms. Cholota was extradited, and we can now add her to the indictment. Had this trial commenced sometime in the past, we would have had to prosecute Ms. Cholota on her own.
The matter once again set for an urgent application.
We are of the view we will not get substantial redress on or around the 11th of September. We wish to avoid a situation where we are incongruent with what we state in our papers, which is this court does not have jurisdiction over the applicant, but then here we are talking about these are the merits of the matter, these are the issues of the matter. It simply will not accord.
Cholota's legal team submitted why they believe she wouldn't obtain substantial redress during pre-trial.
The particular issues that we raise, without getting into the merits of those issues, things such as the unlawfulness, or what we state are the unlawfulness of the extradition, which render the criminal court as not having jurisdiction over her. Our claim is that certain conduct took place that was confirmed at the lower court, that the state did, and that because they confirmed that, that now changes the lawfulness of the extradition, or that casts the extradition in a particular light. If we do not come to this court to seek redress for those actions, in our view, we cannot thereafter, after the pre-trial, come back and say, oh, but we've got one more point to raise. We wish to go to the pre-trial having done away with these issues.
You say that should the pre-trial begin, then you cannot raise this issue.
Indeed, milady.
Why do you say so?
Yes.
Because it often happens in pre-trial matters. Remember, a pre-trial in a criminal matter is not the same as a pre-trial in a civil matter. So it often happens in pre-trial inquiries that one of the parties would divulge to the court that we have an interlocutory issue to dispose of, and it is the following. So the fact that you will go to pre-trial in September does not prevent you from raising this issue.
SABC News, Bloemfontein.